Good morning, everyone. I'm Christina Morrison with Second City Canine Rescue. Welcome to our seminar on how to protect your pet through estate planning. Second City Canine Rescue wanted to put on this community seminar as a benefit to everyone to try to keep pets out of shelters. Ideally, your pet would stay, with you for the length of its life, or a trusted friend or family member who already knows and loves the pet. So this morning I am very happy to bring up Jackie Luthringshausen of Lavelle Law and Bethany Prociuk of Wintrust Wealth Management and Chicago Trust Company NA to talk to you about what you can do to protect your pet through your estate plan.
As Christina said, I'm Jackie Luthringshausen from Lavelle Law. I specialize in estate planning. That's all I do all day, every day is estate planning, and I've done many pet trusts for clients. I am also an animal lover. I have one dog. She's 2 years old. Her name is Boodles, but we call her Boo for short. So I'm happy to be here today because it combines my passions for estate planning and then animals. So thank you guys all for coming. I will just do a general overview of why it's important to have an estate plan, but then we'll kind of zero in on pet trusts specifically. So why have an estate plan? Basically, everybody needs some sort of an estate plan once you're over 18. I think, the word estate plan makes people think it's just for the rich and famous or something like that. But no, everybody needs some type of plan to protect yourself, your assets, and your family. So some of the reasons to have an estate plan are, number one, planning for the inevitable. Unfortunately, we're all going to die someday. I know it's something hard to think about, but the more you plan for it, the more peace of mind you can have about that. So by having an estate plan in place, you can set forth your wishes with respect to who you want to receive your assets after you pass away. You can provide for the care of your pets, as we're going to talk about. All those things that might be hard to think about, if you actually put those in estate plan documents, it gives you peace of mind that when you do pass one day, your wishes are going to be carried out, your families and your pets are going to be taken care of the way you want them to be taken care of. So then the second thing is making sure your wishes are carried out. So you can be very detailed in an estate plan about who you want your assets to go to, who you want to care for your pet. All of those things you can specifically set forth in a plan. If you don't do that, then there are certain state laws in Illinois that will take control and decide who gets your assets. And that might not always be what you want. For instance, if you don't have a plan in Illinois, if you had a spouse and kids, half of your assets would go to your spouse and the other half would go to your kids. Now, those are assets that don't have named beneficiaries. If beneficiaries are named, it always goes to that beneficiary, or if it's owned in joint ownership, then it goes to the joint owner. But if you have assets that don't have named beneficiaries and they're not in joint ownership and they're not in a trust, then that's the Illinois rule, would be half to your spouse, half to your kids if you have both. And that's not always the result that a surviving spouse would want. You would expect, I'm going to get everything when my spouse passes away, and chances are you're going to need those assets to live out the rest of your life. So the state law with respect to where your assets go might not always be the result that you want. So better to have a plan in place and you say who you want to receive your assets. And then the third is planning for stability for your loved ones. Oftentimes I hear people say, I don't need a plan. My kids all get along. No one's going to fight. They'll just figure out who gets what. And I always shake my head because it doesn't usually turn out that way, or, many times it doesn't. When it comes to money and assets and property, as much as your family members love each other, they might fight over who gets what. And sometimes it's even silly things like who gets my leprechaun statue. I mean, you'd think that would not be a big deal, but yes, it becomes a big deal. So best thing to do to eliminate any kind of fighting when you pass is have a plan in place. You set forth who gets your assets. And then there will be no fighting among your family members. If there's fighting, it usually ends up going to court. The court decides who gets what. That's costly, that's time consuming, and can be avoided by having a good estate plan in place. And then finally, with a plan, you leave your legacy. So leaving money to your kids, grandkids, charities that are near and dear to your heart, such as animal rescue organizations, things like that. You can leave that legacy by leaving money to, people and organizations in your plan. So it's kind of nice to know you're leaving behind something that will benefit others. Okay, then the next question is, who needs a plan? Again, it's not for the rich and famous. Everybody needs some kind of plan. Parents with children under age 18, you definitely want to have at least a will in place to appoint guardians. If something happens to you and you haven't appointed guardians, the state is going to decide, the court will decide who's going to be the guardian of your children. Now, normally they'll try to find, a family member to take on that role, but it still might not be the person that you want. Maybe they choose, a sister that you haven't gotten along with for years and years and years. That's not going to be under your control anymore because you left it up to the court. So if you have children under age 18, super important to have a will in place and name your guardians. People with children under the age of 35 even, it's important to have a will or a trust. The reason for that is typically kids don't have their financial brains fully formed until they reach maybe around 35. Sometimes it might even be longer, but you probably wouldn't want your 18, 7, or 20-year-old, even a 25-year-old maybe, to come into a bunch of assets at that age because especially, during the teenage years and young 20s, they might spend the money on video games, sneakers, and maybe, unfortunately, drugs and alcohol. So by having a plan in place, you can actually, especially with a trust, you can build in sub-trusts so that assets that would go to your kids would be held until they reach certain ages of financial maturity, and that would be up to you. That's the great thing about a plan. You can decide what's best for your family members. When we do our plans, we start out perhaps recommending that the kids get a third of the assets at age 25, the next third at 30, and the balance at 35, thinking by 35, most kids are more mature financially. Maybe they're getting married, buying a house, starting a business. So that's kind of where we start out talking. But again, the great part about planning is that you can decide for yourself what's best for your family members as far as when they should receive the distributions. Business owners, great to have a plan in place so you can do succession planning. If something happens to you, you become incapacitated, or when you pass, who is your business going to go to? You don't want your kids to have to fight over that. You don't want a big delay in determining who's going to take over your ownership, and then the business isn't running efficiently during that time period until it all gets worked out. So you can set forth specific provisions in your plan to decide who's going to take over the business, whether it's your kids or potentially other people that such as other owners of the business. Maybe you pass the shares to them. Rental property owners, we can do asset protection through an estate plan. Children over age 18. I don't know if you're all aware of it, but once your child turns 18, you can no longer make health care and financial decisions for them because they're considered adults. So very important for children, once they turn 18, for them to prepare powers of attorney for health care and property. So as the parent, you can still make those decisions for them. They can give you the authority to do that. Because of HIPAA law, privacy law, you won't be able to do that unless the child has powers of attorney in place. They give you that authority as a parent to do that. And sometimes that's a big problem. Kids go to college and you try to call the financial office to talk about the tuition or whatever, and they won't talk to you anymore because the child's considered an adult. So we always run a special every year for college students to come in and do powers of attorney for healthcare and property, to give the parent that authority to keep being able to talk to the doctor, talk to school about tuition and things like that. Obviously, the elderly would want to get a plan in place, thinking about the inevitable, that we're all going to pass one day. And so basically the answer is everybody needs a plan. If you don't have a plan, what happens? The state of Illinois takes over as far as statutory law. Basically, your property will go pursuant to probate law. It's going to go to your heirs as determined by state law, which is they have kind of a pattern of who it will go to. Again, I kind of mentioned sometimes that doesn't work out the way you want it. If you have a spouse and kids, your assets would go half to the spouse, half to the kids. Most surviving spouses would prefer that it all goes to them, so you can avoid what state law says by making your own plan about who you want to get your assets. If you have no will and no executor in place, the court will appoint one. Sometimes that works out fine, sometimes it doesn't. Again, they're going to choose somebody that they think is appropriate, but that might be a family member that you never got along with. So it's better for you to be in control, for you to decide who you want to administer your assets after you pass away. Guardianship, as I mentioned, in the will, you would appoint your guardians. If you haven't done that and you pass away, the judge will decide who will take care of your children. That might not be the family member that you would have chosen, so better for you to decide who you would want your guardian of the kids to be. And then if you have a taxable estate, you won't be able to do any tax planning if you don't have a plan in place, which means you're going to give away more money to the government rather than to your loved ones. Okay, so what are the basic documents in an estate plan? Everyone at the very least should have a will. The will is where you would appoint guardians if you have minor children. Powers of attorney for health care, that's a document where you name an agent, which is a trusted person to make health care decisions for you if you couldn't do it yourself. A power of attorney for property, you would name a trusted person, an agent, to handle your financial matters if you couldn't do it yourself. And then not everybody needs a trust, but when we usually meet with our clients, I'd say, many, many times we decide that a trust is also a great document for them to have in place for all those reasons I kind of mentioned before. Maybe they have young children and they need to hold back the assets in sub-trusts within the trust. Maybe they need to do estate tax planning in the trust. There's more tools that we have with respect to a trust than we have in a will. So the difference kind of between a will and a trust, what does a will do? You can specify who gets your assets in your will, so that's obviously a great benefit to have with the will versus leaving it up to the state to decide who your heirs are. And you can name guardians for your minor children so that you don't leave it up to the court to pick who's going to be the guardian of your children. And you name an executor. That's the person that would step in and collect all of your assets and eventually distribute them to the people you named in your will. Also, if you don't name an executor and waive what's called a surety bond, then the court would appoint an executor, and the executor would have to put up a bond in order to carry out its role as your executor. What doesn't a will do? It doesn't always avoid probate, especially if you own properties. Kind of the golden rule for avoiding probate is every asset has to have a named beneficiary or be titled in a trust. So if you have owned property, that can be a problem because you can't specifically name a beneficiary on the property. You can have joint ownership and things like that, which would avoid probate. But many times with a will, you're still going to end up in probate. Probate is a court-involved process where you have to hire an attorney, go to court, publish notice to creditors, do inventories, and then finally go back to court and close it. It's costly. You have to hire an attorney. And it's just a delay in time. Today in Illinois, most probate proceedings are lasting about 15 months. And during that time, your family members and loved ones aren't getting the distributions until everything is settled. And then with having a will, it doesn't manage your assets if you were to become incapacitated. Your will doesn't hold assets, it just distributes them when you pass away. So if you became incapacitated, it doesn't give anybody the ability to take over and manage the assets for you. Versus a trust. A trust is a legal entity that actually holds and manages your property for you while you're living and after your death. So during your life, if you transfer assets to the trust, the assets are administered for your benefit. You act as the trustee and have total control over the assets and the ability to manage them. And then if something happened, if you became incapacitated, a successor trustee would step in and manage the assets for you, which is, a great benefit to have someone you trust stepping in to handle things for you while you couldn't do it yourself. Then after you pass away, the successor trustee that you name steps in to liquidate all your assets and then distribute them to your beneficiaries that you name. A really big benefit of trust as well is you can completely avoid probate, so there's no court process involved. Your trustee handles all of the liquidating the assets and distributing them. You don't have a judge deciding who gets what and when it's going to happen. It's very seamless, very cost efficient, and not as much time to administer your assets after you pass away. And then also with a trust, assets can be held in sub-trust for the benefit of your spouse, your children, if they're not of the age to be able, or to, that you'd want them to receive all these assets. They might make bad decisions. Loved ones, and then even your pets, as we're going to go into. So estate plan documents can be used to guarantee the care of your pet upon your death or your incapacity. A great thing to take to handle your pet after you pass, because so many of us own pets and love our pets. Today, about 66% of all U.S. households own at least one pet, and one of us had 5, which but our pets become our furry family members. Actually, in Illinois, a pet is considered property, but I'm sure you feel like I do, that they're actually a family member, not just a piece of property. So super important to provide for them, not only during your life, but also to make sure that they're cared for properly when you pass away. Can you provide for a pet in your will? Yes, you can provide for your pet in your will, just like any of your other property. So just as a will will designate people to receive your other property, your house, your furniture, your bank accounts, things like that. A pet, because it's considered property, just like your furniture and artwork collectibles, a pet, you can name someone to receive your pet in a will. You can also provide clear instructions on the care of your pet. And you can set aside a certain amount of money that you give to the beneficiary along with the pet. So you're going to name someone to receive your pet, and then you would also provide money so that the person has funds to provide for the pet for the rest of its life. Is the will, providing for your pet in a will, the best solution? Maybe not. So the problem or issue with providing for the pet only in your will is that there is no oversight over the person who you give the pet to and the money to. So with a will, the pet is distributed outright to somebody as well as the money, and there really is no oversight or guarantee that the pet's going to be taken care of the way you want it to, or that the money you provide for the care of the pet is going to be used to care for the money. Now, hopefully you pick somebody that you really trust that will carry out those wishes, but there really is no control of that. So technically, once the pet is given to your beneficiary and the money, that person could drop the pet off at a shelter and take the money and take a trip. So obviously, hopefully you have, decided on someone you really trust, but there is no guarantee. Also, there is no protection of your pet if you became incapacitated, because wills don't go into effect until you pass away. So if you became incapacitated, you're in, some assisted living or something like that, there's no one that steps in to take care of the pet when you're incapacitated if you just have provisions in your will. Because a will doesn't hold the property. It just distributes it outright when you pass away. So is there a better solution? Yes, the better solution is creating a pet trust. A pet trust is an entity that holds your property and carries out your wishes as you direct with respect to the property, which is the pet. Illinois has recognized pet trusts since 2005, and now all 50 states have enacted pet trust laws. How does a trust better ensure the care of your pet? With a trust, the property, which would be your pet, remains in the trust and ownership is owned by the trust and doesn't go outright to a person. Rather, the ownership remains in the trust, and you have a trustee who oversees that your pet is going to be properly cared for by a caregiver, and also is the person that will oversee the distribution of the funds that you put in the pet trust, the money to take care of the pet. So the caregiver would be the person you name that will take the pet into their home and provide day-to-day care. But the trustee is going to oversee that, is going to be the one to pay out the funds for the monthly care of the pet, and is going to make sure that the caregiver is providing the care that you've spelled out in the trust. So it's a great benefit that you're having someone really oversee the care of the pet and how the funds are being used to take care of the pet. Unlike with a will, pet and money just gets distributed outright, and there's no oversight of what happens after that. So what are the key players, the elements of a pet trust? Number one is you would name a trustee. That could be a friend, relative. Some animal welfare organizations will do that role, or trust companies will also act as a pet trustee. I know Chicago Trust Company will act as your pet trustee. Bethany's going to talk about that in a little bit. So if you don't have a trusted friend or relative that could take on that role, it's a great solution perhaps to name a bank as trustee, because one great thing about that is they have experience at doing it. So that's a great option. You're going to name the beneficiaries. That would be your pets. The caregiver is going to be this, the person that, again, takes the pet into his or her home, provides the day-to-day care for the pet. And then you're going to put aside a certain amount of money, funds for the care of the pet. The trustee is the person that's going to oversee, that the pet is taken care of the way it should be, and also going to be the person that manages the funds in the trust and distributes money to the caregiver when he or she needs it for the pet's care. That could be, it's spelled out in the trust. Maybe they get paid monthly, bi-monthly, whatever. All that you can spell out in your trust, but your trustee will be the person giving the money to the caregiver. So they can't just take it all and buy a new car. Okay, so who should you name as a caregiver? Obviously, the trustee is a super important role because you want to make sure that they're managing everything properly. But obviously, the caregiver is also a super important role, because that is the person that's going to be taking care of your pet every single day. And we all love our pets. We want them to be taken care of, somewhat the way we would have done if we were still there. So number one element of who should you name as caregiver, obviously somebody that you trust, that will really love your pet and treat it, like you would treat it, as if it's their own pet. Provide the loving care that you gave it when you were alive. Next one is to consider who knows your pet well. Now, we might not all have somebody that knows our pet, but if you do, there's obviously a comfort zone. If your pet has been with somebody during its life, like maybe your pet sitter that came regularly when you were alive, a relative that, have spent time with the pet. Again, it's a comfort thing. Your pet's going to grieve at losing you as its owner, but at least if you give it to somebody that knows it will feel that comfort of being with somebody that knows it, and knows, has a relationship already. That doesn't always happen, but if there is somebody that knows your pet, it's helpful for the pet. And then just consider who will be a good fit. You might have a very active dog that you walked twice a day. So you'd want to pick a caregiver that can do that as well for your dog. If you name somebody that really isn't an active person and wouldn't want to walk the dog, that probably wouldn't be a good fit. But if you have a dog that's more of a cuddly couch potato, then you might name someone that loves to just sit and read and cuddle with the pet. So the fit should be good for both the person and the pet. My dog has some separation anxiety, so, I don't think I would want to name someone that travels a lot, because obviously the dog would be very anxious not, having the caregiver home a lot. Or if your dog has separation anxiety, you probably wouldn't want to pick somebody that works in an office, every day of the week, and they're going to be left at home a lot. So, think about the personality of your pet, and then match that up with the right person, the right fit for that role. You would want to consider who understands the responsibilities of owning a pet. A lot of people think that it's, they're cute and they just sit around and you admire them, but that's not what a pet's all about. That's part of a pet, but there is, exercising the pet, feeding it, regularly, vet visits. Maybe your dog gets its teeth brushed on a daily basis. All those things, it takes time, and someone has to understand the responsibility of making sure those key needs of a pet are actually met every day. And then, to your point, different people for different pets. You can lay that out in your trust. Maybe you absolutely want, if you have more than one pet, maybe you absolutely want them to stay together. Set that forth in the trust so that gets carried out. But there may be times where you have, a very active pet that you would name one friend because that person loves to walk and run, and then you have your little couch potato pet that you would name, somebody else for, and those different people fit the personality of the pet differently but better. So just something to consider. And then, does your pet have any special needs? Sometimes pets get daily shots for allergies or diabetes or something like that. You'd want to name a caregiver that can handle that, is comfortable giving shots. So that's something to consider when you choose a caregiver. Okay, other considerations when you are creating your pet trust. One of them is that you want to fund the trust with the appropriate amount of money so that you can provide for the care of the pet for the remainder of its lifetime. How do you determine how much that should be? I get asked a lot. So generally I always say consider how old is the pet, how much do you spend yearly on the pet, and that would be for food, grooming, the vet bills. Sometimes people regularly take them for puppy play dates, things like that. So figure out kind of how much do you spend on your pet yearly, and then multiply that by the number of years left in the pet's average lifespan. So obviously that's different per pet. Most dogs, small dogs, will live to about maybe 18. A bigger dog is more like 12. Cats can live to in the 20s. And I forgot what you said, the turtle is like 50s or a long, long time. But so, you have to kind of just figure out the yearly expenses and then multiply that number by the number of years that the animal probably has left based on the projected lifespan of that type of animal. And then you should always just have a cushion in place for unexpected medical expenses. I never expected my dog to get diabetes, but she did. So then, it would have been good to have a cushion in place so you can buy the insulin, give the shots, all that kind of thing. That, just try to provide for unexpected things like that and have a cushion in place so that there is an issue with the caregiver not being able to provide those things that the dog or cat or other pet needs. Next, the amount should be reasonable. Illinois says that the amount you put aside should not substantially exceed the amount required for the pet's care. So that's all, that amount is all different based on what your pet's needs are, what standard of care they're used to. But basically, you want to be reasonable, otherwise the court could reduce that amount. This is a picture of Leona Hemsley. I have put there, don't be a Leona Hemsley. She left $12 million to her pet, Maltese, and she disinherited grandchildren, but she gave $12 million to the Maltese. And the family went to court and challenged it, and the court reduce that amount to $2 million, which is still a lot of money. But in her case, I think the dog had 24-hour security that was like $100,000 a year, and all kinds of other costs that normal pets don't have. But anyway, you want to be reasonable in what you put aside in the pet trust. It's all up to you, pretty much based on the standard of care it's used to, the number of years you think it has left in its life, and what you usually spend on the dog. Every pet is different, so if you usually give them weekly play dates, you can factor that in. If they need extra medical care for something, you factor that in. But just, you don't want to be unreasonable about what you put in the pet trust, because it can be challenged. Also, with the pet trust provisions, you can be really specific on the standard of care that your pet is used to. So if they usually get grooming once a month, if they visit the vet once or twice a year, they get their teeth professionally cleaned once a year, you can put all that in there, that you still want all of those things done. You can require a pet inspection provision, which would be that the trustee would come in and inspect the pet periodically, whether that's monthly, quarterly, yearly, but the trustee can actually visit and make sure that the pet is being properly cared for. You can require that the trustee gets reports from the caregiver, maybe just at least provide that the pet went to its yearly vet check and everything turned out, okay. Looks like the care is properly being given to the pet based on the vet's report. You can require that insurance is taken out on the pet for liability in case the pet bites someone or damages property or anything like that. You can require health insurance on the pet. And then you should have a contingent plan in case the trust funds run out. What happens if unexpectedly you didn't fund the trust with enough money? What happens? So at that point, the trust would terminate because it's no longer funded with assets. And you should have a contingent plan. Where does the pet go? Do you want it to stay with the caregiver if that person is willing? Do you want to have it given to an animal welfare society? Just something to think about. What is the contingent plan if the trust funds, the money to pay for the pet care, runs out? And then also you could include provisions regarding what happens when your pet passes away. Do you want he or she to be cremated, or do you want it to be buried in a certain place or a pet cemetery? If it's cremated, where do you want the ashes distributed? So all those things you can provide for in the trust, so that, again, your wishes are carried out with respect to what happens to the pet after it passes away. And then finally, if there are assets remaining in the trust and the pet has passed away, once the pet passes away, the trust terminates. But if there's still funds in the trust for the care of the animal remaining, you can name who receives those remaining assets. It could be a family member. You could give the remaining assets to the caregiver as sort of a thank you for taking care of the pet. Or you could name an animal welfare organization, such as Second City Canine Rescue, or some other charity that's near and dear to your heart could be the recipient of the remaining funds in the pet trust, if there are funds remaining when the pet passes away.
And as we've talked about today, we can serve as trustee for a trust that you would create. So including a pet trust. And so here we'll just go ahead and just look at a little bit of who we are. We are licensed in all 50 states, which is a benefit to you should you move, or to your point, you may have individuals that you're working with throughout the country. This is information you'll find in our folder, which I did place at each of your chairs there. But beyond that, we really are a community bank. And so we are happy to meet with you at one of our local branches, as well as we want to service you without a requirement of, let's say, a big downtown bank. We don't have a $5 million minimum requirement in order to provide you trustee services. In addition to that, I did provide my contact information, which you can call me. I promise it's not an 800 number. I will pick up as long as I'm not in the middle of something. But of course, happy to always call you back should you have questions on our services. In addition to this, as you'll see, I like to say the beauty of what I do is I can help after you've met with your attorney in 3 phases of life. And here it kind of outlines what that is. But essentially right now, while you're of full sound mind and you're accumulating wealth, you're investing your monies, we could help as an investment officer if you would need. In addition to that, so that's personal and corporate trustee services. We move into that space as well to help you should you become mentally incapacitated and you can no longer, as a doctor would deem you, unable to handle your financial affairs. So we can step in, we can help with bill pay, tax returns, making sure your property, as like your real estate, for example, is taken care of because you're unable to. So we can serve as an agent under your power of attorney for property, and similarly, if you create a trust, we could serve as your successor trustee. Then we do some specialty services as far as we settle estates, but that's the 3rd phase, we'll get to that. And obviously guardianships, which you've probably heard of, famous guardianship cases that have gone on, we can serve in those matters. Britney Spears is a very publicly discussed guardianship case recently. In addition to that, we have charitable trust, special needs trust that we manage and help with, and some of the specialty services, including pet trust. Now, obviously, the 3rd phase, which we can help with, is your estate settlement. And a pet trust is created, as we learned earlier, at your death. And so our job would be to, as your executor of your estate, marshal in all your assets, find out where they all are, where your animals are located. If you've got a horse that you've boarded in another state, it's our job to figure out where all of your property is as executor to settle your matters. And then based on the documents that you've drafted, that's our blueprint. We're able to go ahead and, because of the map you've provided within your documents, carry out your wishes, which we call control from the grave. So you've spelled it out for us so that we can truly move ahead with what your wishes are, including within pet trust. And I always like to say, and I have a popular podcast individual I follow, she says, being clear is being kind. And I really truly believe within your documents, if you make it helpful to the trustee, the executor, your wishes, as we talked about a little bit today with pet trust, grooming once a month. All of those things are really helpful for us to know what your wishes are and what we can approve as far as distributions from your pet trust. If it's clear to us you want them to be on a specific vitamin or what have you, that's really helpful to us because a caregiver could essentially take the money and run. So it's clear for us with how you have it outlined within your document. So in addition to that, I think, today is just helpful for you to know if you don't have a trusted person or a trusted person that you hoped that could carry out your wishes when you're unable to is no longer available, that's where we can be a service to you. And I know it's really tough. It's amazing how many instances we see where you name your neighbor, your best friend, your partner, your child, and their life circumstances have changed by the time it comes to fruition for them to serve. And so a lot of the attorneys like Lavelle Law office that we work with, they tend to draft in banks, corporate trustees as an option because of course we don't have a crystal ball. No one does. And so there's wisdom in factoring the worst case scenario. And I hate to say it that way, but that's what your estate plan gets to allow you to communicate, is if my child's unable to, then I need a secondary option. Similarly, I think as a corporate fiduciary, it's incredibly helpful when you name a caregiver that you name more than one, because it's a shot in the dark for us to try to figure out who would love the animal that you have grown to love to the best of their ability. You have a better sense of their true personality, their character, and what they'll invest into your pet, or pets. So nonetheless, by all means, please call us if you'd like to discuss some of the things we do. We do help as far as property. One of the prior questions goes, it is our job, whether it's a piece of artwork or it's a pet, we do have to get that property to where it's supposed to be. And so that's some of the services that we provide when we are corporate trustee for you. So please, if you have any questions, this is just some of the advantages as a fiduciary versus an individual. Obviously, we're held at a higher standard. We would provide accountings, but we also, we do have to hold the caregiver accountable based on what you draft within your document. So we want to make sure, as clear as you can make it, to help any trustee. I think you'll be satisfied and you'll be able to rest peacefully, so to speak, once you get it all down on paper on what your wishes are.
So thank you, Bethany. That was very helpful. We talked about how Chicago Trust can be a contingent trustee and handle the finances. So I wanted to talk about how Second City Canine Rescue can help with caring for your pet as well. So let's say you create your pet trust, you name your neighbor, your best friend, your relative as the caretaker, and then you also name a successor caretaker. And both of those caretakers either pass before you or they have a change in life circumstance and they can no longer take your pet. If you have adopted a Second City Canine Rescue pet, we give a lifelong commitment to each pet that we adopt out. So we would absolutely want your pet to be returned to us if you cannot find a friend and family member who already love the pet, they know the pet, and it would be a fantastic home for that pet. We don't want to be in the position of being a caretaker where we don't have legal ownership of the pet. So what would happen is if you have a Second City Canine Rescue pet, the dog would return to us. We would take ownership of it. We would close out, or your trustee would close out the pet trust. We would adopt out that pet to a new loving home. Even if you do not have a Second City Canine Rescue dog, because we only do dogs, feel free to come talk to us. We are happy to talk to you about it, help you make your plans. We would also, appreciate funds to help care for the pet if the pet ends up coming to us. But regardless of whether the pet is a Second City Canine Rescue dog or a dog from another shelter, we could talk to you about taking it in, but we would want ownership of the pet so that we could pass off ownership to a new family. There's one last thing I wanted to talk to you quickly about. Second City Canine Rescue is using this seminar to launch our Legacy Society. So we talked about, what do you do with any assets that you have after you pass. You can give them to friends, family members, neighbors, and you can also make charitable donations to 501c3 organizations, and you get a little tax break for that. So we would of course love to be included as a way for you to support us when you no longer need your assets. A lot of people want to hang on to their assets while they're still alive in case they need nursing home care, long-term care of any kind. So this is another way that you can support us when you definitely don't need your assets anymore. So I hope that you will think about us and our Legacy Society. We're asking that people tell us that we are in their will, trust, estate planning documents so that we can celebrate you during your lifetime. We'll have events for you and, name you if you want to be named as being a part of our Legacy Society, and just celebrate you as a supporter of Second City Canine Rescue. So we've got a brochure on the front table about how to do that. So other than that, feel free to come up and ask any other questions, and thank you so much for coming today.